You're listening to the Signs of the Times podcast, a production of the Center for Social Concerns at the University of Notre Dame. Here you'll find conversations on human dignity, solidarity with the marginalized, and the common good, all basic principles of Catholic social tradition and how they relate to current events.
Hello, everyone, and welcome to the Signs of the Times podcast at the Center for Social Concerns at the University of Notre Dame. I'm JP Shortle. I'm the Director of Communications and Advancement at the Center for Social Concerns. And I'm joined today by two guests we're really happy to be talking with, Robbie Craig and John Dacey. Welcome, gentlemen.
Thank you. Happy to be here.
Yeah, thanks for having us.
So John Dacey is the Executive Director for Abolish Private Prisons, which is an organization seeking to end for-profit prisons in the United States by challenging the constitutionality of them in court. And Robbie joins him in this effort as the Associate Director of Abolish Private Prisons. So welcome to you both. I'm really happy to have you joining us. And we'd love to hear, first of all, introduce yourselves a little bit and tell us how you got involved in Abolish Private Prisons. Why don't we start with you, John?
Yeah, I've been practicing law in Phoenix for, since 1977, and was doing some mediation work maybe 8, 9, 10 years ago regarding prisoner lawsuits against the Department of Corrections over things like safety and medical care. And it was while preparing to do that work, I first learned for the first time about the existence of private for-profit prisons. And as soon as I read the words, it hit me at a deep level. No, this is the government's responsibility. And the more I read about them, the more I became convinced this is a modern form of slavery. So I decided to do something about that, and we created Abolish Private Prisons as an Arizona nonprofit. In 2015, we're a tax-exempt 501c3, and we filed our first lawsuit to challenge the use of private prisons on June 15th.
Oh, and we'll certainly want to hear more about the lawsuit. Before we do that, though, Robbie, could you tell us a little bit about how you got involved?
Sure. I graduated law school and I clerked for 4 year, 1 year on the Ninth Circuit, and 3 years in a district court in Tucson, District of Arizona. I had known John for a while. I had done some volunteer work for him on a previous project. And so I had some time in between my clerkship and taking the bar, and got put in touch with John again and started volunteering on the Abolish Private Prisons project. And doing the legal research really captivated me as both sort of a moral and a legal issue. So we worked together for, it was 4 or 5 months on a volunteer basis. And then we were working towards getting my position funded. And then once that happened, I joined full time. And we've been working that's been about 3 years now that we've been working up to the culmination of the filing of the first suit that John just mentioned.
Great. And so we hear a lot these days, and have heard for some time, about the problems of mass incarceration, right? And especially, I think, at least in the university where I am, following Michelle Alexander's book, The New Jim Crow, we started to hear an awful lot about it, and to have really sophisticated discussions about it in our university and others, I'm sure. But why focus on private prisons instead of the problems of mass incarceration?
It's certainly all connected. The privatization of prisons is connected to mass incarceration, and because government has funded this industry, it has also created a powerful lobbying interest that, like any private industry, wants to sustain itself and grow. And when you're in the business of incarcerating people, your growth is by incarcerating more people. And that can have a spillover effect to what our laws say and how they spend their money at the state capitals and Capitol Hill on criminalizing behavior, resisting decriminalization alternatives to incarceration and the like. The numbers right now are at about 10% approximately on the number of prisoners across the country that are in private facilities. The majority of the states use private prisons, as do 4 federal agencies, but some states don't. And those numbers can change dramatically and quickly. So if a state legislature like Arizona or Tennessee considers legislation to privatize its entire corrections system, the numbers can change very quickly. I think fundamentally, we can talk about this one question for the entire hour or however we have allocated, but I think one thing that we do is we see this as an issue about the interpretation of the Constitution, where a small group of people can have a big impact. The typical jail and prison case is not about the law, it's about the facts on the ground, and it requires a massive investment of resources. This is about the Constitution. And we see the private incentive to incarcerate and to keep people incarcerated as a cancer in our legal system. And you don't wait until it completely metastasizes. You go after it quickly, as soon as you can. That's why we picked this issue, because we can. And you have to start someplace.
And I think when you consider the kinds of, when legislatures are determining what is the right punishment for a crime, what does a criminal justice system look like, and you think about the kinds of people that you want in the room that are making that decision and the kinds of things that they're thinking about, is this the morally right thing to happen for somebody that's committed this action? What's the best outcome for society? How do we make sure that people are the least likely to recidivate? We want experts in the room. And the one thing that I think is it's a pretty basic issue to understand is when that decision is being made, what shouldn't be in the room is the question of profit. You shouldn't have anybody in there that's trying to convince people that here is what the criminal justice system should look like, when all that they're trying to do is make sure that they increase the amount of money in their pocket. And if you can get them out of the room, then you can have a real conversation about what does criminal justice look like. So I think it's a slightly different wrinkle in why do we start here? And I think it's because once you knock out that profit motive, then you can have a real conversation about what should it look like.
Sure. And given, if you get to the point when you can have real conversations about what the system should look like without the profit motive, those are going to be long and complex conversations as it is, right? So the quicker you get to those, it sounds like the more likely you'll get good results sooner down the road. John, what were you gonna?
Yeah, to be certain, we're not suggesting that privatizing certain governmental functions is wrong, or that making a profit is wrong. Public-private partnerships are successful all the time. What we're saying, though, is that there has to be a line somewhere when you're talking about the most fundamental deprivation of a person's liberty. And in our view, that's the government's responsibility alone. There shouldn't be any profit incentives that affects what happens inside the walls, or whether someone is inside the walls at all.
Yeah, well, and you mentioned how easy it might be for a state legislature to go toward private prisons, even though, as you said, right now only 10% of the prisons in the country are private. Is that right?
Well, 10% of the prison population is private. So most people in private prisons are placed there by the states. There's a higher percentage of federal prisoners in privates, but they're a small number compared to the number of people in prisons through the states. Where you get a high percentage is with the immigration detainees, where 2/3 to 70% of immigrant detainees are being placed in these private prison facilities.
And although we talk about it being 10 to 12% nationwide, those numbers vary dramatically. So, a state like New Mexico is approximately 40% private. So it's one of those things where in certain places the numbers change, and like John said, those numbers can change very quickly. And one of the things that you really don't want to happen, and the reason that it's important to go after it early, is you want to get to these industries before they become too big to fail, which is, if a state like Tennessee or Arizona turns it over to a private corporation, the entire prison system, which has been considered, the chance of being able to go back from that is a lot harder once it's been established, because you lose the departmental institutional knowledge. You lose, the unions and the training and all of those things that go into running a system. So we think it's really important to stop it before it becomes this thing that is too big to stop.
Sure, that makes a lot of sense. And even in John's description of the way the system starts to grow at the beginning, you could start to sense how there might build a kind of momentum, like systems and especially governmental systems do build a kind of momentum that would be tough to stop if you let it go for long. Now, when you said that New Mexico, for instance, has a pretty high percentage of prisoners in private prisons. When New Mexico went in that direction, what were their reasons? What was the rationale for them going there?
I don't know when they started. So with Arizona, which is where I'm familiar, it was in the early 2000s. To go back a ways, if I could provide a little bit of historical perspective.
Please, sure.
So the United States really starts to go off the rails with the number and percentage of people we incarcerate. In the late 1970s, 1980. Coincidentally, the private prison industry is birthed in the United States around 1980, when there was a big push to privatize governmental functions. Well, it developed under the radar in some states, primarily in the South. And in 1986, it caught the attention of the American Bar Association. And one of our board members at that time drafted a resolution that was adopted by the American Bar Association in 1990 that called for a moratorium on private prisons and jails until the complex constitutional issues were identified and resolved. Obviously, that didn't happen. And in the late 90s, the Clinton administration decides to start using private prisons at the federal level. So different states jump into this market, if you will, at different points in time due to different needs. So Arizona initially used private prisons out of state. We now have 12 private prisons in Arizona, 6 of which are used by the state of Arizona. We import prisoners from other states to these private prisons, and the federal government also uses them for immigration, pretrial detainees, and people convicted. The state of California, for example, started sending prisoners to Arizona because they were looking at contempt sanctions from federal judges due to their overcrowding. Well, the short-term solution was to send prisoners to Arizona's private prisons. So the history of it, my guess is part of the history was from the governmental standpoint. Here's an answer to overcrowding. Well, it's a short-term answer. It's, in our view, an unconstitutional one. There were other ideas that perhaps should have been contemplated, but we are where we are. I suppose from an industry standpoint, your position would be the government said it had a need, we provided a solution, just like any other kind of governmental contractor.
Sure.
And the pitch when you make this argument to the legislature is, one is overcrowding. You have these prisoners, you don't have a place to put them. We can help with that. The other one is we can do it more cheaply. If you're spending $64 per bed on average, we can do it for $59 or whatever the difference is. That turns out probably not to be true. There's ongoing research about that. And it's not clear one way or the other, but what does seem clear is that sort of the big money savings that they pitch don't seem to be panning out. The other way that they pitch the whole idea of privatization is the same as in other places, other industries, which is we can experiment, we're more agile, we don't have the bureaucracy, so we can figure out better ways to provide programs for less money. We can design facilities that are encouraged, that encourage less recidivism. So you can see from a theoretical perspective why the idea is intriguing, and it's the same kind of pitch that makes privatization or public-private partnerships intriguing in other areas. It just gets really messy when you include someone's liberty and those perverse incentives that happen when you're paying per bed per year, and what that means.
To be certain, while we talk about some comparative studies, we are not making a comparative challenge to the existence of private prisons, that public facilities are better. Public prisons, of course, have their own problems, serious problems. Our position is you don't get to those comparative discussions until you first decide it's constitutional to do this in the first instance. We believe it's unconstitutional in the first instance. These facilities should not exist.
Yeah, that's well put. And it's also, it's easy to see how once, the pitch is made to a state legislature on the basis of cost savings, it's easy to see how that could crowd out a whole set of complex questions that ought to be being asked during such considerations. But the profit motive and cost savings motive are so powerful that there are lots of instances when they crowd out lots of questions that should be asked.
Yeah, and there's another part of it too, which the way that most prisons get funded is through local bond issues, right? You have to raise the capital to construct the prison. So you go to the county or the municipality and you say, will you pass this bond issue? And eventually people were like, no, we don't want to do that anymore. And that's what led to some of this overcrowding. And so to get around that, what the state legislature can do is they can contract with this private facility, private company. They say, we'll build a facility so you don't have to go get a bond. And then you can just pay it, through the sort of regular legislative appropriation. So it really pulls the accountability, the direct way that a person in a locality can say, this is my way that I'm going to make a statement. We shouldn't be imprisoning more people. I'm going to vote no on this bond issue. That used to be basically the only direct check that an individual had. And now that's been taken away because they just circumvent the capital construction costs.
Yeah. So how many private prison companies are there in the United States? You have
I'm ballparking here. I'm ballparking at maybe 150.
Wow.
It's been a while since I've looked at the numbers nationally.
Is that for facilities or companies, John?
No, that's for facilities. There are three big players that dominate this market, two of which are publicly traded on the stock exchange. So Corrections Corporation of America was the largest. They rebranded to CoreCivic in 2017. The GEO Group used to be known as Wackenhut. CoreCivic's based in Nashville. Wackenhut is, they're in Florida. I think it's Boca Raton, GEO Group. And the third one, which is not publicly traded, is Management and Training Corporation out of Salt Lake City. And those three companies have more than 90% of the incarcerated population in private prisons. And all three are significant players in Arizona.
So I know both of you have thought a lot about, you're talking about the problematic morality and unconstitutionality of private prisons. But I know you've also devoted a lot of thought to the problems with privatization in the prison industry in general. What are some of those problems? I mean, John, you started us off by saying when you first heard about this, it seemed pretty quickly to you to be something akin to slavery. That's a strong claim. What are some of the problems?
If you think about slavery in the American experience, of course, we're thinking about African slavery and complete ownership and subjugation of people to private owners. And we think of it not just in those terms, but more expansively. So if you think about what happens when you privatize your prisons, each prisoner becomes a unit of profit to the corporation and to the value of the shares to the shareholders. So the prisoner becomes human inventory on corporate balance sheets, whose lives are effectively bid on through public procurement. And they may be transferred from Vermont or Alaska or Hawaii to Arizona in shackles to a location in Arizona where a huge corporation is going to make a profit over their existence here. Now, I'm not suggesting most prisoners in Arizona come from those locations. They have. Most of them presumably are from Arizona. But you have a circumstance where each prisoner becomes a cog in a machine. One prisoner means the same as the next to the corporation in terms of profit. So that's one thing. And if you just look at publicly traded shares of these corporations, well, the value of the shares go up as they incarcerate more people, get more contracts. And the contracts for a certain number of lives are assets of those corporations, which are then used to borrow, encourage investment. And when you look at their filings with the SEC, for example, of the publicly traded prison corporations, they make it fairly clear to their shareholders and potential investors. Criminal justice reform is not in the best interests of the profitability of the corporation. So criminal justice reform, alternatives to incarceration, decriminalization, lenient judges, all can diminish the value of the shares of the private prison stock. So in that sense, the prisoner just becomes a commodity.
Yeah. Yeah. So it is that reduction to a commodity that we think is a key part of why we feel comfortable calling it slavery. And I think in addition to that, putting it in the historical context that John mentioned a little bit earlier, but when you think about what happened, starting in the pre-colonial era through the 13th Amendment, you had the chattel slavery that we all sort of is in the American conscience about, what we think of when you hear the word slavery. Immediately after the passage of the 13th Amendment, in order to sort of make sure that these mainly Southern plantation owners could continue to extract value from primarily African-American people, they set up this convict leasing system through these vagrancy laws, largely in the South. And so they criminalized Black existence. And then they passed these laws and said, if you didn't have a job, that was reason that you could be put in jail. And then they would, once they were in jail, the localities would then turn around and lease them back to the same people that were the slave owners originally. And then after that, you have these Jim Crow laws. So putting it in the context of how can the government sanction private individuals or corporations to extract value from people? And that's where the line goes from slavery straight to private prisons. And at every step, there's been this government sanctioning where the government creates the rules that allows usually white and wealthy people to make money off the bodies of largely colored people. So it's this direct line that we think helps put the slavery claim in context.
So there are both good theoretical and historical arguments then. The theoretical argument being that it turns people into a commodity, and the historical one being it sounds like fairly easily established historical connections between chattel slavery and prison. So thanks for elucidating that for us. John, what were you going to say here?
Yeah, I mean, Robbie's explanation it also puts in context why we've sued the Arizona Department of Corrections director and not the private prison industry. It is the government that is responsible for this. Just as the government was responsible for slavery before the Civil War, with the Dred Scott decision from the U.S. Supreme Court, or the language in the original Constitution on fugitive slaves, it is the government's sanction of this practice that we're objecting to. So what our lawsuit seeks to do is invalidate any state laws that authorize Arizona to participate in this process and the contracts themselves. And we intend this lawsuit to be a model for similar lawsuits in other parts of the country.
Well, so since we're starting to talk about the lawsuit itself, can you describe for us some of the grounds for the lawsuit? And as you do, maybe talk to us about the constitutional arguments against private incarceration?
Sure. Rob, do you want to run with this one?
Sure. The first one relies on the concept of due process in the Constitution, which basically says you have to be treated fairly. And that's the procedural part of it. And then there's a substantive part of it that says you have basic human rights as an individual that the government can't take away. So when it comes to the procedural part, we say, look, there are these financial incentives that really make it more likely that your liberty is going to be taken away. And there's not much that the government can do once these incentives are in play to protect that most important liberty interest. And then on the substantive rights side, we say, look, part of what it means to be a human is not being treated like property. That's embodied in the 13th Amendment. It's part of the 8th Amendment when it comes to cruel and unusual punishment, which is a separate claim, but it's tied in. Because one of the things that the 8th Amendment cruel and unusual punishment clause says is that we're going to look to contemporary moral standards to see whether you're being treated appropriately. So that covers the 14th and the 8th Amendment. And then the slavery claim, which we've been talking about, the 13th Amendment says no slavery nor involuntary servitude except as punishment for a crime shall be allowed in these United States. The except as punishment for a crime exception has gotten a lot of attention recently. The documentary 13th, there's sort of a public understanding that exception allows for slavery to exist today. Interestingly, that really hasn't been tested in the courts. And so one of the things that the lawsuit seeks to do is to say, does the punishment exception, does that apply to slavery? Or does it only apply to involuntary servitude? Is there a categorical ban in the 13th Amendment on slavery? We think there is. But even if that punishment clause does apply to slavery, we also think that if you look into the historical record, the congressional debates, what they were looking at from the Northwest Constitution, Northwest Territories, that clause was inserted in there to make sure that states could continue to have prisons operate. And so we think that there's a public punishment exception, not a private punishment exception to the 13th Amendment. Those are the main claims in the lawsuit that we filed. We're also planning to file lawsuits against the federal government that includes a different claim that for some technical legal reasons we can't bring against the state of Arizona. And that's the non-delegation theory. And that's the one that John mentioned a little bit earlier when he said there's just some things that the government can do and nobody else can. And so primarily when the non-delegation doctrine has been litigated in court, it's about Congress attempting to say that the president or the executive branch can make these regulations. And there's a limit on how much those regulations can look like laws and how much guidance Congress has to give the executive branch when they make those. But there's also a private non-delegation doctrine, which says that the government can't delegate certain things to private companies. And so that's what in our view, taking away somebody's liberty is at the core of what the government only can do.
And the issue on that non-delegation raises a bigger, broader issue on what the government can privatize in other areas. It's not part of the lawsuit, but can government delegate to private parties the conduct of public elections? Can we privatize the entire United States Army? I mean, where are the limits to what we can privatize? And we're not suggesting there's any clear answer, but we do believe there's an answer here.
Yeah. Well, and it would seem so. So Robbie mentioned earlier privatization trends in general in this country for decades. It would be easy, given those trends, to sort of look across the board and say, when privatization is good in one arena and saves money there, for instance, it must be good in others, right? And we fail to distinguish between various spheres. And I think when we fail to distinguish among various spheres, we're going to land in all sorts of trouble. And I think, because of the current historical moment, the non-delegation argument, while extremely compelling, I think might be difficult to make because so many are convinced that privatization is generally good. And they don't make distinctions and say, well, it could be good for X, Y, and Z, but not for A, B, and C.
Yeah, I think my personal perspective on this is 10 years ago, I would have 100% agreed with you. I think we are starting to see a bit of a sea change in that. I think people are starting to say, hey, wait a minute, why isn't the government doing this? How did we get to where we are today? And so not only does that happen, one of the things that tends to get lost in the discussion is the sort of wide range of people that support criminal justice reform, right? It's 15 years ago or something, it might have been seen as a sort of lefty progressive issue to say, hey, we're putting too many people in jail. As the costs have started to mount and people have started to see the moral consequences of it, you're seeing a sort of libertarian pushback. You're starting to see large church and religious organizations get involved in this effort. And that creates a big sort of, social push on that. And there is a, keeping in mind who sits largely in federal courts these days, there's a conservative pull to the non-delegation theory, which is that government shouldn't be that big in the first place. And so why are we giving these fundamental government powers to private companies who have the incentives to make them bigger? So I think you're right that we often do fail to differentiate between kinds of privatization, but I think there is starting to be a bit of a pullback and say, let's examine the concept a little bit. And I don't think we're where we want to be yet, but I think we're starting to see some momentum in that direction.
There was actually a conservative U.S. Supreme Court during the Franklin Delano Roosevelt administration, and when FDR and the Congress were seeking to expand government programs to deal with the effects of the Great Depression, you had a conservative Supreme Court knock down some of those delegations on the basis of the Constitution. And so what Robbie was just talking about is that there has been some look back by justices today at maybe we shouldn't have abandoned that doctrine. And there's more activity on it now.
Mm-hmm. One of the places, the battlefield that this non-delegation idea is being fought at the state level. It hasn't got a lot of momentum in federal courts yet, but states are starting to question like occupational licensing, for example. And that's a conservative issue to say, are we really going to make our cosmetologists get 18 months of training before, they can work on people's appearance? There's been some conservative state Supreme Court decisions that say, hey, wait a minute, whose right is it to say that I can't go to somebody and pay them to do these things that I want them to do? And in writing these opinions, they've laid out the principles of this sort of autonomy and, smaller government, and what right does this private person have to say that this private person can't operate in the field. And so we think when you talk about these sort of work interests, that's the same in legal theories. Those are both liberty interests, the right to work and the right to be not in prison. So this liberty thing, this sort of concept, human dignity and liberty, it's across the aisles. Everybody sort of understands that you have rights as a human. And so that's something that we think is crucial to the non-delegation thought.
Yeah. Well, it's interesting and engaging and compelling for lots of reasons. The work you're doing is, but now we've stumbled into what seems to me to be something that makes it really basically politically interesting. And that is this idea that, concepts like liberty and human dignity are so basic that they're bringing together, a coalition of interests that you might not expect these days, right? Because we hear all the time how divided we are, that we can barely get together on anything. So it seems to me you have to dig pretty deep into the foundation to find something so basic that it can manage to bring us together. And of course, liberty and human dignity are pretty basic. So from a general political perspective, it's interesting for that reason. So can you all tell me where is the case right now? Where are you on the?
So we filed the complaint and served it June 15th, June 16th. And the state's response right now is due August 17th. Presumably they'll file a motion to dismiss, but if not, their answer is due that date. And the case will take off with substantive briefing from there. At the same time, as Robbie mentioned earlier, we are preparing a second case that will make similar claims against the federal government for its use of private prisons in Arizona. It will take time. COVID has complicated everything, including, the timeliness of court proceedings and how they're conducted. So we don't know how that'll play out, but we're just at the beginning of the first lawsuit on this issue.
So I don't have any legal training and I'm not a lawyer, but I do know that lawsuits can be extremely expensive. How are you financing this effort?
Well, there's two ways to do it from the get-go. One is to bring in money to hire lawyers. Another is for lawyers to volunteer their service. And that's what we have, the latter. So Robbie and I both work for Abolish Private Prisons, but one of our co-counsel from Tucson, Tom Slackett, former Chief Justice of the Arizona Supreme Court and trial lawyer, also a fellow Notre Dame grad, by the way, is a co-counsel. We have Frederickson and Byron, a 300 to 400 lawyer law firm in Minneapolis that has committed 4 lawyers to this cause. And we have at least a half dozen other lawyers working with us behind the scenes. So that's another way to do it, is for other firms to throw in with us, especially as we look to file more lawsuits and in other parts of the country. So to the extent we've got any grads who have retired from practice and are still wanting to do something, we've got something they can do.
And in terms of funding Abolish Private Prisons, like most nonprofit organizations, we rely on both institutional grants, which we work with people to apply for and seek out foundations that have similar goals as us, and also individual donations, through sort of crowdfunding efforts and people who are philanthropy minded. So yeah, that's one of the reasons every time somebody hears our name, if they're thinking about what they can do with $5 that they saved on a cup of coffee because Starbucks is closed right now or something, think about us if you can, because like John said, we're a really small organization. And as you noted, it takes a lot of money to see a lawsuit through to the end.
On that concept, the cup of coffee. So we've been privileged to speak at the Center for Social Concerns several times. And, we make the pitch. If some students wanted to give up the $5 this semester, but more importantly, convince their classmates and their friends on other campuses across the country to do the same thing. Yes, you're right. It will take significant resources to get this issue before the United States Supreme Court. If I can use that as a segue to JP, think of Brown versus Board of Education as a model for what we're trying to accomplish, where Brown was actually the consolidation of 5 different lawsuits in front of the U.S. Supreme Court, Brown being the first one filed, I believe, where the court, number one, reversed existing Supreme Court precedent, saying separate but equal is the law of the land. We don't face existing Supreme Court precedent on these issues. Second, it declared it was the law of the land that segregated public schools had to go away. That's the kind of relief we're looking for nationally. And the reason we chose the courthouse, and of course we welcome working with all kinds of other advocates and forms of advocacy. But the reason we chose the courthouse is because of the model I just mentioned, Brown. Not to be political, but in 2016, the Department of Justice, on the basis of a 70-page report detailing serious problems with private prison contractors, the Department of Justice said, we're not going to use private prisons anymore. We're going to let the current contracts run out. We had an election 3 months later. A new administration came in and said, we're rescinding that, and we're going to use private prisons even more. Well, this industry has grown up under Dems and Republicans. But the point being, with a constitutional decision, you can't just wave your hand or go to the state legislature and change the result. So that's a reason to go to the courthouse. A small number of people can have a huge impact on this issue. The other thing I hope you don't mind me commenting on, I used the cancer analogy early in this discussion. This profit incentive in criminal justice is already metastasizing. These corporations are creating subsidiaries to handle for-profit probation, for-profit parole, community corrections, ankle bracelets, bail bonds, and going global. This industry is spreading in the United Kingdom, Australia, Brazil, France, Germany, and there's some common ownership. So this is happening now. And this is the time to do something about it, when I think the public is so energized to seriously look not just at criminal justice reform, but the incredibly disparate impact that our criminal justice system has had on people of color.
Yeah. Well, I want to thank both of you for joining me today and for talking about this remarkably complex and, I think, really important issue. It's been really great to talk with both of you.
I encourage everyone, take a look at our website, abolishprivateprisons.org. Well, thank you so much.
When this gets posted on the website, on the center's website, we'll have a link to your website in the description of it when it goes out. So again, thank you all for joining me, and good luck in your good work.
Thank you. Thanks for having us.
Take care.
Goodbye.
Thanks for tuning in to the Signs of the Times podcast. If you liked what you heard today, make sure to subscribe in your podcast app or leave us a review. Follow us on social media at ND Social Concerns to stay connected, or find us online at socialconcerns.nd.edu.